So everyone that was in the waiting room is in the main session. All right, so we are going to be calling Calderon. So Mr. Darren, let's see if he's connected. You're on mute. Oh, he's in another court, looks like. Okay, Mr. Gremban.
Yep.
Good morning.
Good morning.
Which case are you here on today?
It should be under Gremban versus Lovett.
Yes, at 8:45. All right. Let me just check you in. So I'm going to place you back in the waiting room.
Thank
And
you.
when your case is called, we'll bring you back in.
Sounds perfect. Thank you.
Okay, Ms. Calderon.
Yes, ma'am.
Good morning. You have video?
Oh,
Yes, ma'am.
sorry, Jennifer, I'm doing two at once.
Okay, no problem.
I want to withdraw my motions.
Okay, because the judge did, we did process.
Yeah,
those
sign the
orders
order.
yesterday. Yep.
And Ms. Calderon called me when she received everything and we
Okay.
got it all situated. I don't think I received the signed child support order yet.
Okay.
But
Go ahead and accept the invitation to wait.
we set it to 0 as
Yep.
well. So,
Yes.
I
So when I processed this yesterday, I was wondering if this would need to proceed. So, okay.
no, it doesn't. And was not able to get in the office at all yesterday to try and follow up with it. So I apologize, Melissa, but
No problem.
Oh, it's okay.
I got tied up in a felony non-support case all afternoon. So
No problem. So I'll check on that child support order to see, make sure it didn't get lost in the queue, and make sure you get a copy of it.
yeah, and then I'll just, obviously I'm going to withdraw my motions and everything. So we're good to go.
Okay. All right. Well, have a great day.
All right. Thank you.
Thank
Thanks,
you.
Melissa. Take it easy. And I'll forward those orders to you as soon as I get them. Okay.
All right. Thank you.
Yep.
Bye-bye. All right.
And then I'm all set to just leave.
Yes, absolutely. All right. Have a great
Thank
day.
you. Have a good day.
You too. Bye-bye. All right, Mr. Gremban, good morning again.
Morning again.
All right. Good morning, Ms. Wilson.
Good morning.
And we've got Ms. Coleman. Good morning. Okay. What else are we waiting for on the Lovett v. Gremban matter?
I'm sorry, there's an echo on my end. What was
Yes,
that?
I'm not sure why. I wonder who. Okay, someone's speaker.
Wow. I'm on a computer speaker, so
You're on a computer speaker. I can hear myself.
did you want me to mute myself again?
Let me just check something. Let me see.
Could be a phone.
Let's see.
Everybody should turn off their phones if they're on a computer.
Yes, possibly. Now, since I muted Mr. Gremban, it's gone away. So let's see. Could you unmute yourself, Mr. Gremban?
There we go.
Okay, so is it on? Oh,
Yes.
no. So you're on a PC or a laptop?
It's a laptop.
Okay, for some reason there's some reverb.
As I said, it could be a phone.
Yeah. You want two devices or just one?
No, I'm just on one device.
Okay.
My phone's silent on the other side of the room.
Okay. So are you waiting for any other parties for this matter?
My gosh, I'm hearing myself bad. My client should be coming in any minute.
Okay. Let me see. We've got a couple more people in here.
That's my client.
Okay. Okay, good morning.
Good morning.
Morning.
We've got parties for Lovett v. Gremban. Gremban. And so, ma'am, with the iPhone, you can identify yourself.
Teresa Planton, or you may have me down as Teresa Stratton.
What time is your case today?
9:15.
Okay, really early.
Yeah, I'm sorry.
That's okay.
You are-
Okay, so I'm going to place you in the waiting room.
Okay.
Your case is called, okay?
Okay, thank you.
Okay, so we've got all parties now for Lovett v. Gremban.
Yes.
Yes.
Okay, all right, so the judge gets in 1 moment.
Recording in progress.
Calling case number 19151-586 deathh Lovett versus Gremban.
Counsel, your appearances for the record.
Good morning, Your Honor.
Judy Coleman representing Samantha Smith, who is the appointed guardian for the minor children.
Good morning, Your Honor. Kaylin Wilson on behalf of defendant father who's appearing via Zoom.
Okay. Good morning.
Good morning.
Ma'am, can you state your name for the record?
My name is Samantha Smith, also known as Samantha Lovett.
And your name, sir, sitting next to her?
Cody Smith,
Okay, your relation?
husband.
Okay. And Mr. Gremban, can you state your name for the record, please?
My name is Adam Gremban.
Okay. I'm going to have the three of you raise your right hand. Do you swear or affirm that the testimony that you give during these proceedings will be the truth and nothing but the truth?
I do.
Okay, you can lower your hands. I'm getting some feedback.
It's probably from I was muted in the lobby.
Okay. Let's mute you again. Thank you. Okay. For now. Okay. The last time we were here, obviously the guardianship was granted.
On a temporary basis yesterday, yes.
Okay. Oh, that was yesterday. Okay. And so what would you like for this court? What are your arguments today?
Well, Your Honor, my position is that I believe that Ms. Coleman's clients have everything they need right now with the temporary orders of guardianship. My client is requesting that I file a motion for reconsideration in the probate case. We are returning in that case on July 25th, and it's my understanding the court is going to do some investigating so the judge can be provided some more information. So my position is any determination in this case today would be premature until we have a final resolution in the guardianship case. So I would ask for an adjournment until after the July 25th hearing.
Ms. Coleman, are you in agreement with that?
No, I mean, no. We obviously believe that there was no palpable error, and so there's no really reason for a reconsideration motion, but obviously Ms. Wilson has the right to file one.
Okay. Well, of course, then this court is going to allow time for that probate court matter to be heard. So I will schedule this for a new date after July 25th, and then that may resolve this matter in its entirety, or we may be going to an evidentiary hearing. So we'll give you a date for a new hearing. And until that time, there's an emergencies. Obviously, you can file an emergency motion to anticipate that. But is there anything else?
Judge, on the date that you give us, will that be the evidentiary hearing, or Or will that be at a future date?
What we can schedule for, we can schedule that evidentiary hearing for that day.
Okay.
Yeah, there's no need to do two more.
Yeah.
Yes. Yes,
Thank you.
I'll make sure that we do that. Okay?
Yep.
Hold one moment, we'll get you a date.
Okay.
Okay, we have September 28th at 9 a.m.
What day of the week is that?
Actually, hold on one second, that may not work.
9:51.
Okay, no, that day is fine. And that's at 9 a.m. And that, I don't have my calendar. What day of the week is that?
That's a Thursday, it looks like.
Okay, that's a Thursday. And evidentiary hearings are in person. We'll send you an evidentiary scheduling order. Now, Mr. Gremban is not in the state of Michigan?
He does not live in the state of Michigan. He is in the state of Michigan currently.
Okay, so he can attend in person on the 28th of September?
I will leave that up to him only because of his employer.
Yes, I can be there in person that day.
Okay, very good. How old is the child?
There's two children, Your Honor. One is 8 and one is 6.
Okay.
And Your Honor, I'm assuming if we don't reason have a final resolution regarding by that point, then we can contact your court to move this matter.
Absolutely.
Okay, thank you.
Okay. Anything else?
No, thank
Nothing
you.
from me, Your Honor. Thank you.
All right. Everyone have a good day.
Thank you, you too.
We're sure.
Recording stopped.
All right, guys. So just to get a quick recap, obviously everybody saw that this was adjourned to September 28th, 9 a.m. It looks like. I saw somebody did mention, which I thought his attorney should also ask about a schedule about seeing his kids. The problem that's going to rise here, and you already saw the aunt's attorney, which she properly did, in stating that they are the appointed guardian, right? She took that label and that title very quick, and that tends to set an impression, right? In court, it's all a presentation, it's all a dog and pony show, and opposing counsel is immediately trying to present as if this is the status quo. Dad's attorney, I think, did a great job of kind of redefining what that meant, in that it was assigned yesterday on a temporary basis. Unfortunately, one of the things that I can see happening here is status quo kind of setting in. We're looking at September, so that's about 3 months away. Surely at that point, opposing counsel is going to argue that the kids are doing well. They're in therapy, they're in schooling, the community and the family. So, to move them, especially with a child that's autistic, we saw opposing counsel quickly highlight that. That's probably going to be part of the argument, at that point. Hopefully, Dad can figure out some sort of a schedule to start seeing the kids. And, it's gonna be tough. When these things get delayed like this, it tends to favor the status quo, and surely opposing and the aunt are going to do everything possible with their new rights that they just gained to ingrain the kids in everything and anything that they can in Michigan, which will make it that much, more difficult for dad to be able to, pull them to New York. On the overall basis, I argue a lot of times about following procedures and the process and the way things are. And while obviously there is some truth to that, on the surface, this is pretty ridiculous. And it's absolutely infuriating that any parent, whether it be mom or dad, that they just wouldn't inherently be able to get the rights to their own kids. There is something wrong when a parent dies, that the other parent doesn't immediately just get full rights and full custody. I understand what the court's theory is and the best interest of the child, and obviously I advocate, not advocate on that, but I advocate on just learning the process, playing the game. And this is part of the game, but it still doesn't mean that it's not infuriating. And seldom are the cases that really kind of infuriate me personally, and this is one of them, because there's no other moment or no other slap in the face to any parent, whether you're a mom or a dad, that you have to convince strangers that you should have the right to care for your own kids. I really don't care what the situation is. There should not be any situation outside of maybe something absolutely grave that should prevent that. In this case, I understand the argument that opposing counsel used yesterday, regarding the child being autistic and, going to therapy and what that disruption could be. And listen, that does make sense. And should dad and the attorney been better prepared for that? Absolutely. Should they have already had a medical game plan in the Bronx? Absolutely. Because you have to play the game, right? That's just the game. The court is going to come to that. The court's going to default to the best interest of the child. And, when you have a child with a medical condition, that's always going to be paramount, whether we agree with it or not. So I do think that they should have been better prepared with that, at the minimum, and if anything, just with that, but even with that being said, listen, families move all the time, kids move all the time, kids are placed in foster homes all the time, and kids adjust, right? Kids are resilient. And is the child going to struggle, in a new environment? Sure, everybody does. But it's just infuriating that a living parent would have to justify, when there is nothing major, there's no allegations of abuse or anything of that sort against that would prevent dad from getting it. So with that being said, I'm going to calendar this, and I'm going to put this up in the group so that we can have at least, this is the family court hearing. I think we have probably another probate hearing coming up. Probably, I think it was a month, if I'm not mistaken, that they said yesterday. So I'll calendar that as well, so we can kind of keep track of this. I think it's critical, outside just from the emotional perspective here that we all get on this, that we also look at this for what it is, right? And we learn from how the process works. And as much as we can be infuriated about what this is what it is. This is the process. This is the game. So, doing what we need to play the game does not detract from our emotional perspective on what's happening. And so I want to stress that enough, right? We just have to play the game. So with that being said, Adam, you know, if you hear this at some point, you know, continue to feel for your man, and you know, prayers, and hopefully you can get something up so you can see your kids and your kids can see you, right? Because the one thing they do need is a parent around them in these difficult times. All right, guys. So everybody have a good day. I think we have another hearing coming up. I think within the next week or two. I got to check the calendar. So we'll carry that live as well, so that hopefully we can get some learning from those also. All right. Have a good day, everybody. Talk to you soon.